different doctors might recommend different treatments, and it's a judgment call by the physician, and just because what he did may have had an unintended complication or a risk or a known risk, it doesn't mean, again, that what he did was negligent if he acted reasonably.
So what you're saying is you may get a bad result, but that doesn't mean, you know, that the doctor did something wrong because he used a judgment which is an acceptable judgment in that particular case.
Yeah, Lisa brings up a good point. Oftentimes, you're going to a doctor is going to, in every procedure that takes place, there are risks, not risk, but there are expected bad outcomes that are just part of medicine. Medicine is not 100% certain. And, you know, for instance, you have surgery and you're going to go have anesthesia. There is a certain population, a certain group of people that are not going to survive anesthesia. Now, that doesn't mean that somebody was careless. That's just a known possible risk of a medical negligence.
So what happens if, in a case where you do have it reviewed and you decide that there's a case, can you just go ahead and file a case, a lawsuit?
Actually, no. It's a little bit more complicated than that.
Okay, we're going to take a break in just about 30 seconds, so can you tell me just briefly, and then we'll come back and we'll finish up what your thoughts are on that. What is needed, and then we'll talk about what you need to have that.
Once your expert reviews the case, they have to be willing to sign an affidavit that there was negligence and that there is a viable case.
Okay. I think we're going to take a break in about 30 seconds, and we'll come back with the follow-up about when you do have that affidavit, what really needs to be in the affidavit, and then let's talk about actually filing a lawsuit and what goes on with the lawsuit. So this is the Illinois Law, sponsored by the Illinois State Bar Association, and we're talking about professional negligence with my guests Susan Zwick, Ronald Kalish, and Lisa Velez, and we'll be back just 1 minute to finish our discussions.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Mister!
Over and over.
It's our problem! Leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest...
Generation after generation.
I hate you! I hate you too!
Isn't it time you stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathas, and I'm your host, and we're discussing professional negligence. We've talked about nursing home cases, and we're now currently talking about medical malpractice cases, and if we have time, we're going to try and get into professional negligence of attorneys. My guests are the Honorable Susan Zwick, Ron Kalish, and Lisa Velez. I think we had finished up, we were actually getting into talking about this affidavit for filing a lawsuit. And what's the reason behind an affidavit? And again, maybe you can tell us, Judge, what it is. I kind of cut you off there when we went to break.
The reason behind the affidavit is to ensure that when a medical negligence lawsuit is filed, that it's viable and it's not, and excuse me the term, it's not a frivolous suit. You can see from the earlier part of our discussion that when you file a suit, it's an expensive suit. It means records have to be reviewed. It means people's lives, you're investing in the issue. And if a suit is frivolous, you're wasting a lot of people's time and money. And that might seem harsh, but it's a reality. So by having an expert review, you not only ensure that the case is viable, but you also have an opportunity to determine whether or not it truly was negligence or it was an aberration.
And you know, the affidavit serves, I think, a dual purpose. Not only does it protect physicians and medical care providers from frivolous cases, it also reassures the plaintiff, the person who was injured or the family who's bringing this case, and the lawyer bringing it, that there's been a medical doctor who's looked at this and signs
There's some process going on, to some protection at least, to at least evaluate a claim so people aren't just bringing lawsuits you know, for no good reason or without at least good investigation.
It does, and you know, when doctors or hospitals get sued, that's a very serious allegation, and so the law is in place to protect those people.
Now, in a medical malpractice case, once a lawsuit is filed, what is the procedure from the start of the case to the finish of the case? And maybe you can talk about from the plaintiff's perspective, and you can talk about the defense, what is involved generally, and then, Judge, you can tell us what happens as the case, you know, isn't resolved by the parties, what other steps are taken.
Sure. After you have the affidavit signed by your expert, the next step is to exchange information. That's through written papers, and it's also through depositions, which is when you give testimony or give your version of what happened under oath with a court reporter. Once that occurs, ultimately all of those records and all of the deposition transcripts get reviewed by an expert. Sometimes it can be the expert that looked at the case at the beginning, the person who signed that affidavit, or it can be a multitude, not just one expert, but maybe 2 or 3 experts.
Are experts needed in medical malpractice cases?
You must have medical testimony from an expert establishing what the standard of care should have been in the particular allegation of your case in order to pursue a case. You must have expert testimony that establishes what the standard was and establishes that the doctor or hospital or nurses breached or violated that standard of care.
And what happens after the plaintiffs are finished doing their things?
Well, and just to touch on something that Ron mentioned and that we also discussed earlier, you know, even though we know a lot about medicine and everything, it's still an inexact science, and so a doctor is going to be judged by whether or not they acted as a reasonably well-qualified physician of their same specialty. So say they're an emergency room physician, then they're held to that standard of what a reasonably well-qualified emergency room physician would do under the same or similar circumstances.
So do you need a doctor or nurse or whoever it is that's in that specialty field to testify? I mean, you just can't grab a doctor off the street and say, hey,
Correct.
testify about this?
Right, it would have to be someone who's practicing in the same specialty or area of medicine. So again, because doctors aren't perfect, and so and that's not the standard that they're being held to. So from a defense standpoint, plaintiff mentioned the need for experts. Well, we would also have an expert as well to show, you know, that the doctor's care did comply with what a reasonably well-qualified physician would have done under the same or similar circumstances, and then at some point, plaintiff identifies an expert. Sometimes it's the same person who authored their report. Sometimes it's someone different. Defendants would as well identify their experts, and then they would go through the deposition process, meaning the experts would be deposed. Eventually, if that doesn't resolve the case, then it would be ready for trial.
Okay. And if your case gets ready for trial, and by the way, how long do medical malpractice cases usually take to get to trial?
A little bit longer than the other ones.
And is it usually a couple of years at least?
I would say that on the inside it's 2 years, on the outside it's 4.
And then what happens when the case does get to the trial judge for either trial, or if there's some attempt at trying to settle cases, and what do you do?
Even more so than other cases, even during the discovery phases. The attorneys who are usually involved in a medical negligence case will do everything they can to resolve it. You're talking about professional negligence. You're talking about a mistake that could cost somebody their lives or their livelihood. So there is an obligation between both sides to try to seek a resolution even before it gets to the trial stage. And oftentimes they'll come in and they'll talk to a judge and they will ask for a pretrial. And they'll ask for the judge to sit down and review the case and maybe talk to the parties and see if it could be resolved. So on medical negligence cases, it may take 4 years to get completely through the system, but it usually sees the judge's eyes within the first year.
How about time frame?